ಗೋ ಅಂಡ್ ಡೈ ಅಲ್ಲ, ಗೋ ಅಂಡ್ ಡೈ ಅಂತ ಬೈದಿದ್ದೀರಾ ಅಂತ ಹೇಳಿ ಅಲಿಗೇಷನ್ ಅದು.
Allegations, your lordship, is
would seek to demonstrate that the allegation made in the complaint by the son that the reason for death of his father is that the hurling of abuse by the present petitioner, quote unquote, go and die. Though a precious life is lost, it would not mean that the accused who has not committed those acts of the ingredients of the offense under section 306. ಏನಿದೆ ಜಗದೀಶ್ ಸರ್?
306. Investigation has been started.
ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಆಗಿದೆಯಾ? ಎಂಟ್ರಿ ಮಾಡಿದ್ದಾರೆ.
ಹೌದು.
ಎಲ್ಲಿ? ವಿವೇಕ್ ರೆಡ್ಡಿನಾ?
ಹೌದು.
Engage the service of DR Ravishankar is coming.
Which matter, sir? Which case?
This matter.
ಯಾವುದು? 4514.
I am the petitioner.
Sir, nimdala.
ರಾಜಣ್ಣ.
Yes, madam.
ನೀವೇ ರಾಜಣ್ಣ?
Nane Swami.
ಆಯ್ತು.
They have made me as an
ಆಯ್ತು. ನಿಮ್ ಕೇಸ್ ಇದ್ದಾಗ ನೀವು ಆರ್ಗ್ಯೂ ಮಾಡಂಗಿಲ್ಲ. ಬರ್ಲಿ.
Ravishankar is coming. Kindly pass over, madam.
ಎಸ್ ಜಗದೀಶ್ ಸರ್. ಲೀಲಾಧರ್ ಎಲ್ಲಿ? ಹೌದು ಸರ್, ಬನ್ನಿ. ಗೋ ಅಂಡ್ ಡೈ ಅಲ್ಲ, ಗೋ ಅಂಡ್ ಡೈ ಅಂತ ಬೈದಿದ್ದೀರಾ ಅಂತ ಹೇಳಿ ಅಲಿಗೇಷನ್ ಅದು.
Allegations, your lordship, is after the land that has been sold, claims to have sold, it is a security for the purpose that the land has been given. And thereafter it has not been given. Then when there is a call took place in the land, and he was cultivating the land. Thereafter the incident took place, your lordship, that is annexure. FIR, the complaint, your lordship, in page number 29, your lordship. Sorry, 22, your lordship. The relevant portion, your lordship, in 23. That is, ಈ ದಿನ ಬೆಳಗ್ಗೆ ಸುಮಾರು 7:30 ಗಂಟೆ ಸಮಯದಲ್ಲಿ ನಮ್ಮ ಚಿಕ್ಕಪ್ಪ ಚಿನ್ನೇಗೌಡ ತಂದೇಗೌಡ ಮನೆ ಬಳಿ ಶಂಕರೇಗೌಡ ಈ ಹಿಂದೆ ನಮ್ಮ ಹೆಸರಲ್ಲಿ ಸರ್ವೆ ನಂಬರ್ 53/5 ಯಾವಾಗಲೂ ಯಾವುದೇ ಕಾಳು ಮಾತ್ರ ಶೇಷ ಮೃತಪಟ್ಟಿದ್ದು ತಿಳಿಸಿದಾಗ ನಾವು ತಕ್ಷಣ ಹೋಗಿ ನೋಡಿದಾಗ ಸಂಗತಿ ನಿಜವಾಗಿ ನಮ್ಮ ತಂದೆ ನಮ್ಮ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 53 ಜಮೀನಲ್ಲಿ ಯಾವುದೋ ಕಾಳು ಮಾತ್ರ ಸತ್ತು ಬಿದ್ದಿದ್ದರು. ಅವರ ಜೇಬಿನಲ್ಲಿ ಒಂದು ಚೀಟಿ ಇತ್ತು. ರಾಜಣ್ಣ ಲಾಯರ್ ಆಗಿದ್ದಾನೆ, ತೋಟದಪ್ಪ ಶಂಕಪ್ಪ ಎಂಬುವರಿಗೆ ಬಹಳ ಮೋಸ ಮಾಡಿದ್ದಾನೆ, ಅಸಲು ಬಡ್ಡಿಯನ್ನು ಕೊಟ್ಟಿದ್ದೇವೆ, ಕುಟುಂಬ ಹಾಳು ಮಾಡಿದ್ದಾನೆ, 2 ಕುಟುಂಬಗಳಿಗೆ ನ್ಯಾಯ ಕೊಡಿಸಬೇಕೆಂದು ಇತ್ಯಾದಿ ಬರೆದಿದ್ದಾರೆ. ದಿಸ್ ಇಸ್ ದಿ ಡೆತ್ ನೋಟ್. Because though the loan has been cleared, they have not reconveyed the said property. When they are cultivating the land, then it has been actual, so that he has been committed. But there are other 2 cases that though it is pertaining to the said land, and they have been not successful in getting the relief from the civil court. So that whether the death note as written is true or not, then the investigation has to be.
ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಹೋಗಿ ಸಾಯಿ ಅಂತ ಹೇಳಿದಾರ. ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ
I read it, because a death note has been found. Whether it is a death note written by the deceased or not, it is a matter to be verified by the trial.
ಅವರೇ ಬರ್ದಿದ್ದಾರೆ ಅನ್ಕೊಳ್ಳಿ ಬಿಡಿ, ಅದಕ್ಕೇನೀಗ. Let it is deceased only has written the death note.
Yes, your honor.
No doubt, no problem. ಅದ್ರಲ್ಲಿ ಏನ್ ಡೌಟೇ ಇಲ್ಲ.
If that being the case, your lordship, then your lordship, the reason for his death is the reason why the person has been created, who has got security as a sale deed has been executed, property has not.
ಅಷ್ಟೇನಾ?
That's what I am supposing. Because I can't be made more than that what has been found in the records.
Simple. The petitioner, the sole accused, who now faces allegation of abetment to suicide, hyphen, the suicide of father of the complainant,
Shankare
stands at the doors of this court seeking its quashment. Heard the learned senior counsel D.R. Ravishankar appearing for the petitioner and the learned counsel H.P. Leeladhar representing the complainant and the learned additional SPP representing the state. Facts enumerated are as follows. The complainant and the petitioner is a practicing advocate. Certain civil litigation were pending between the family of the deceased and one Jayarame Gowda for close to 3 decades prior to the date of death. The issue in the list pertains to a certain piece of land of 4 acres and 10 guntas, which was placed as surety to a particular transaction. Though the loan had been cleared, on the act of the present petitioner, it is alleged that the loan had the land had not been released from the said surety. Therefore, the father of the complainant consumes poison and commits suicide. The acts of abetment to suicide now falls upon the present petitioner. The moment the crime is registered, the petitioner is at the doors of this court, and this court has protected the interests of the petitioner by grant of an interim order of stay of further investigation. The learned senior counsel, taking this court through the documents appended to the petition, would seek to demonstrate that the allegation made in the complaint by the son that the reason for death of his father is that the hurling of abuse by the present petitioner, quote unquote, go and die. And the further reason is that the land that was subject matter of surety was not released, or despite released, was not handed over, all by the acts of the present petitioner. The learned counsel appearing for the respondent, H.P. Leeladhar, would however refute the submissions in contending the learned senior counsel submits that none of the ingredients that are necessary to drive home an offence under section 306 of the IPC, for which the ingredients of section 107 are necessarily to be present, are conspicuously absent in the case at hand. He would therefore seek quashment of the proceedings. The learned counsel H.P. Leeladhar, representing the complainant, would reiterate the contents of the complaint and contend that the matter is at the stage of investigation. In a case of 306, which is abetment to suicide, investigation in the least must be permitted to be continued. Therefore, would seek dismissal of the petition. The learned counsel, learned additional SPP, would also toe the lines of the counsel appearing for the complainant and seeking dismissal of the petition and conduct of investigation. I have given my anxious consideration to the submissions made by the respective learned counsel and have perused the material on record. The above narrated facts, dates, link in the chain of events are all a matter of record. The petitioner now stands charged, albeit by way of an FIR, for offence punishable under section 306 of the IPC. Since the entire issue has now triggered from the complaint, I deem it appropriate to notice the complaint. The complaint reads as follows, page 22 to 24. It is the case of the complainant, the son of the deceased, that the father had certain parcels of land which was subject matter of certain proceedings, and the long ago, about 4 or 5 years ago, the petitioner ನಿಮ್ಮ ಹೆಸರಿಗೆ ಮಾಡ್ಕೊಂಡಿದ್ದೀರಾ?
ನನ್ನ ಮಕ್ಕಳ ಹೆಸರಿಗೆ ಮಾಡಿದ್ದೆ.
The petitioner had transferred the lands to the names of his children, and therefore there has been cheating on the case. The complainant alleges that the father of the complainant had been cheated. They cheated. What is not stated in the complaint is plethora of civil proceedings pending qua the subject land, which was not today, but about from 3 decades. Be that as it may, the further allegation in the case at hand through the complaint is that the petitioner has hurled abuse against the father of the complainant, that he would not return the land and quote unquote go and die. Whether this would amount to abetment to suicide is what is necessary to be considered. Abetment to suicide at the relevant point in time under the IPC is dealt with under section 306. Section 306 reads as follows. Section 306 has its ingredients under section 107 of the IPC. Section 107 reads as follows. Section 107 deals with abetment of a thing. If the offense under section 306 has to be proved, the ingredients as obtaining under section 107 are necessarily to be present. They are goading, instigation, proximity to the crime, and the victim not left with any other option but to commit suicide. The interpretation of section 306 and 107 of the IPC need not detain this court for long or delve deep into the matter. The apex court in plethora of cases has considered the purport of section 306 and 107 of the IPC and has quashed those proceedings even at the initial stages on the reason that uttering words within bracket, quote unquote, go and die would not become an abetment to suicide, nor the civil transaction pending for ages and any act that is not proximate to the incident that has happened would become an offense under section 306 of the IPC. The apex court in 2025 SEC online SC page 2332 has in Yogendra Kumar Yadav has held as follows, para 16 to 18. A little earlier to the said judgment, the apex court in 2025 SEC online SC page 1938 had held as follows, para 17 to 23. In the light of the aforesaid judgments of the apex court, what would, if the facts obtaining in the case at hand is considered on the bedrock of the elucidation of the apex court, what would unmistakably emerge is that the crime in the case at hand cannot even be permitted to be investigated into, as the necessary ingredients that are necessary for an offense under section 306 of the IPC are not present even to its semblance in the case at hand. Therefore, if investigation is permitted, it would become an abuse of the process of the law and result in miscarriage of justice. Though a precious life is lost, it would not mean that the accused who has not committed those acts of the ingredients of the offense under section 306 must be permitted to undergo the rigmarole of investigation or trial, as the case would be. For said reasons, allowed quashed.
Macho.
Yes.